Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. Today we're looking at Backsports versus McClunkey, a recent Labour court decision that raises big questions about the enforcement of restraint of trade clauses, especially where an employee is dismissed rather than resigns. So Mr. McClunkey, a senior stream lead, was dismissed after just under 10 months of service, and Backsports tried to stop him from working in the same field, citing a restraint clause in his contract. But the court found that the company hadn't shown a protectable interest and that its dismissal of the employee effectively waived its right to enforce the restraint. In this episode, we're going to be discussing the legal principles around restraint clauses, the importance of proportionality and fairness, and what this actually means for the balance between employer interests and a worker's right to earn a living. How are you doing, Debbie? We're inching closer and closer to these 4-day weeks here in South Africa, and honestly, I just think we've earned them.
I'm looking forward to these short weeks. It's one way of reducing South Africa's work week to 4 days. We just have so many public holidays.
I think today's episode hits on something far less relaxing, though, or far less exciting to look forward to, because it's all about what happens after, employment ends, and especially when it ends badly. So diving right into it, Debbie, what are your initial thoughts on the case?
Well, firstly, Aisha, I just recognize how many restraint of trade cases we've had this year already. Since the beginning of the year, I think we've had 4 cases, and we're only in April. 2 of these in the High Court, 1 in the Labour Court, and 1 in the Labour Appeal Court. So I think it's a timely episode to start reflecting on restraints of trade. It's a tricky area of law. It involves law of contract in as much as it involves labour law. So there are issues of jurisdiction and where's the best house for disputes and enforcement of restraint agreements. And then this particular case, the Backsports case, also involves the question of what happens when an employee is dismissed, and is a restraint of trade agreement enforceable after a dismissal. So an interesting case.
I think so too, and it's really interesting that you note that we've had so many restraint of trade clauses cases this year alone. So it's very interesting to see how we look at Backsports in particular alongside these other cases that I think you're going to mention throughout the episode. But what are the key implications of the Backsports case for employees and employers? Does it shift the standard for enforcing restraint clauses, or would you say that it reaffirms existing worker protections?
So actually, I think all 4 of the cases that have come out this year, and we'll put links in the narrative to all 4 of them, do reaffirm existing worker protections. In most cases, the restraint of trade agreements have not been enforced. Mostly for the reason that the courts are finding that there's not a protectable interest. In the one instance where the restraint of trade agreement was enforceable, this is the decision that's gone all the way to the Labour Appeal Court. It really does settle our law. In terms of, lessons for what are the takeaways for and the key implications, it's really it is about how employers manage restraint of trade agreements in the contract of employment, and ensuring that they are drafting the terms in a manner that is not too broad, that is not vague, but in fact identifies what is the proprietary interest that the employer is protecting, and ensuring that the provision is reasonable. So I think the implication really falls squarely on the employer to ensure that they have drafted restraint clauses in a sensible way. Otherwise, the clauses will not be enforceable.
I think to a certain extent, the judgment, when I read it, it seems to have suggested that I think the employer was actually using this restraint not to protect confidential information, but almost to punish the worker post-dismissal. What do you think we should take away from this in terms of fairness or proportionality, especially when enforcing restraints?
So yes, actually the judge takes the view and states in paragraph 29, the applicant or the application was intended to and had the consequence of ruining the first respondent's livelihood and career. And then at paragraph 30, that the application has nothing to do with the applicant's protectable interest, but has to do with making the first respondents suffer. So these are very strong words. And of course, the key factor and the starting point for any enforcement application is to show that there's a protectable interest. So that really is the first step. There must be a protectable interest which the employee has threatened. Otherwise, the employer won't get out the starting blocks. But before I get there, what hasn't come up in this case or in any of the others the impact on a restrained employee is one of not only not having your freedom to choose your trade or your occupation, but also the potential impact on one's livelihood, which the judge has picked up. And it raises the question of consideration. Are restrained employees being paid in return for giving up their freedom, or because the restraints are restricting their ability to work? And I haven't seen, in any of these cases, discussion of consideration. Of course, consideration might not necessarily be required where there's a strong protectable interest. And so it does go to the question of reasonableness and public policy and weighing up the interests of the parties. But I do wonder if this has something to do with the lack of success in enforcement of restraint of trade agreements, that it's really very much one-sided in favor of the employer without the reciprocity for the impact that the restraint has on the employee. But of course, the key factor is whether or not there's a protectable interest and some specific proprietary interest which the agreement protects. So these are trade secrets or specialized knowledge, and not just the general know-how the employee has and should be able to apply to ensure their economic sustainability and to develop their own careers post-employment. In this particular case, there really wasn't, or the case it doesn't reveal the extent to which there was a protectable interest that the employer was seeking to force the restraint on. And so the restraint was quite broadly stated. It was, that the employee may not compete with a company in any business which trades in any field of activity which is substantially similar to any of the fields of activity referred to in the clause. And these fields of activity are marketing, sales, distribution of corporate and promotional products. And the geographical area was very broad as well. Every province of the Republic of South Africa. And so including, arrangements that have been entered into within 6 months of the termination date. So it's broadly stated, and it does appear the behavior of the ex-employee was questionable. And clearly there was evidence that he was seeking to poach ex-fellow employees to the point of harassment, that he had approached the ex-employer's customers looking for work. There were allegations, that he was trying to take down the ex-employer's broadcasting truck, whatever that means, but some sort of sabotage was hinted at. The judge goes on to say that the application focuses on alleged criminal acts which have nothing to do with the enforcement of restraint agreements. Perhaps, this is a case for, using the mechanisms for protection from harassment, which would not be in the Labour Court. When the enforcement is sought after a dismissal, that the employer has in fact waived the right to enforce because of dismissal, that's a questionable outcome of the case, particularly in cases where the dismissal was lawful and fair. And so the judge's view, he didn't have to go this far in making a comment even on the fact that there was a dismissal involved, because he found that there wasn't a protectable interest. So the dismissal wasn't central to the reason for the court's finding. But I would suggest that there are instances where restraint of trade would survive dismissal, particularly where the dismissal is fair. On the other hand, there might be instances where the dismissal results from where there's a termination due to a repudiation by the employer, in which case the employee may be released. On the 28th of March, there was an application for leave to appeal, so it's clear that the employer does want to appeal this case. The application for leave to appeal was dismissed, but there is a right to petition the Labour Appeal Court, so it may be perhaps the employer will do so. We are bound by the facts as we see them in the judgment, and they're relatively short judgments. Most of these cases did not appear that the employer was forthcoming around providing more detail around a protectable interest. But it remains to be seen how this case might be decided if indeed the employer does approach the Labour Appeal Court.
You're listening to the Labour Justice Barometer, and we'll be right back. I'm so glad you mentioned about, the whole reason. And we mentioned our summary at the start of the case, but I think one of the crucial parts to remember is that the applicant in this case was actually charged with 7 allegations of misconduct, which is very important to take into context. And thinking about that and thinking about how the employer or the restraint in this context, it almost came across as vindictive by the employer. And that's, I think, why the court saw through it, especially when the worker didn't choose to leave. So I think going into my next question, do you think that this case actually sets a precedent that will influence how courts interpret restraint clauses going forward, especially in circumstances like back sports where the employee didn't actually resign but was dismissed?
I'm not sure that it would have set a new precedent in that regard. I think, more importantly, the Labour Appeal Court's decision in the Torrente and other versus Grant Monaghan and Associates Incorporated. I think if any precedent has been set recently, or really an affirmation of our existing principles, we should look to the Labour Appeal Court rather for guidance in that regard. And in that case, in fact, the restraint agreement was held to be enforceable, but it was narrowed by the Labour Court, and this was confirmed by the Labour Appeal Court. And perhaps just a little bit about the facts there. This involved a student intern in a medical context. In all three of the other cases, they related to the medical profession. But in this particular one, the employee was a former student intern who had requested that the employer, in fact, train her to become a proficient practitioner in medical orthotics and prosthetics. And so she was employed by the employer, and she gained her qualification there. The employer, I think, incurred a cost of 1.5 million, according to the facts, to support her training. And she subsequently continued to work with the employer for a period of 4 or 5 years before she resigned to set up her own practice. And so in this case, there was evidence that she had engaged with patients even during her employment to inform them that she was setting up a new practice, and she'd given out details. In this case, both the Labour Court and the Labour Appeal Court were prepared to enforce a restraint agreement, but they narrowed the agreement to restrain her from conducting business close within a 27-kilometre radius from the applicant, which was narrowed from the whole of the Gauteng area. And then I think the employer's initial restraint clause was for a period of 2 years, and the Labour Court, confirmed by the Labour Appeal Court, narrowed that to a period of 1 year. So, there was very clearly a proprietary interest that needed to be protected. The patient's access, she had engaged with patients during employment, and the details that she obtained through her employment with the employer. Court was prepared to uphold that, but to narrow the restraint clause. But in terms of precedent, the court again states the decision in its Basson versus Chilwan and sets out the factors that would be considered in terms of, very much looking at, is there a protectable interest? And if so, has that interest been threatened? And then even if that interest has been threatened, there needs to be a consideration both qualitatively and quantitatively against the interests of the employee or former employee not to be economically inactive and unproductive. So the restraint, must be reasonable, and that could, as I mentioned earlier, include whether or not consideration has been given. And then lastly, is there an aspect of public policy that requires the restraint either to be maintained or rejected? So the precedent, this is a 1993, the Basson versus Chilwan is a 1993 appeal court decision. All four of the cases mentioned the decision, and it's really reaffirmed by the Labour Appeal Court. On the question of, whether or not the employer waives the restraint clause, I think that would depend on whether or not the employer has repudiated the contract or behaved in some way unlawfully or unfairly. But in an instance where the employer has dismissed fairly and lawfully, there may well be good grounds for enforcing the restraint agreement.
So I think, thanks for that, Debbie. I think that was very useful for us to know, especially since there will be other cases that we'll be including in the description, like Debbie said. And I think it just goes to show that whenever it comes to dismissal, it kind of changes the dynamic entirely. So it obviously just requires a lot more careful drafting and enforcement when it comes to restraint of trade uses. But final question, using our labor justice barometer, how would you rate this judgment in terms of fairness and the protection of workers' rights? I think before I let you answer that, I think from my side, and I think like we've also discussed this when it comes to looking at it from the employee's perspective, I think this judgment does a really good job at falling in the green, protecting the workers' right to earn a living, and I think also just holding the employer accountable for any kind of misusing of the contractual tools. And it also respects, I think, the legal precedent, particularly requires this, looking at this imbalance when it comes to competing interests after dismissal. But what do you think, Debbie? What are your thoughts on this?
Yes, Aisha, I think from the employee's perspective, certainly this does appear to be a green in the sense that employees are not being held bound to restraint agreements where there's not a protectable interest or where there's some unreasonableness in terms of the restraint itself. But it is concerning perhaps that employees are having to defend their freedom, to trade or to pursue an occupation and indeed to earn a livelihood. They're having to defend their rights in these cases. I think the greatest impact of the decision, and perhaps it's employers here who really do need to rethink their approach. And in this regard, there have been a number of articles. We can again provide the links. There was one, Jamie Lee Jacobs from Harold Gee, and there was an article by David Short on Mondac, which really give advice to employers, and they would be encouraged to follow this advice, but ensuring that contract terms in a restraint agreement are not vague. They cannot be poorly drafted. They need to ensure that they are narrow and tailored to the employer interest. They must clearly define what constitutes confidential information, what is being protected. They must be updated. And they must show how the employer's role, the mandate that the employee has, the employee is in fact having access to this information or trade connections, and instances that could constitute a breach of the restraint clause should be raised. So it really does require employers to think about what is the protectable interest. The pricing that you can get off a company's website, or if you phone them, or the customers that they publish widely about on their own websites, that's not confidential information. Yes, the specific relationships that the employee may have with those customers, and therefore have an influence over them, arguably that could be a proprietary interest, but then should the employer be providing consideration? Yes, I am restraining you, but in exchange. So there must be that reciprocity. So yes, I share something of a green, but perhaps a bit of room for reflection.
I definitely agree. I think it's one of the very few that we've had as a green case so far in terms of employee rights and looking at it from the employee's perspective. But I'm very happy that you actually also, acknowledge, especially in this episode, that, there's still always room for improvement. But it shows that there's a lot happening in the labor space this year to look forward to, especially with already so many cases coming out just on restraint of trade clauses. I think that's all we have for today. And thank you so much, Debbie, once again. And again, to all our listeners, all the info of what we discussed is in our description.
Thanks, Asha. See you soon.
This podcast is not intended to constitute legal advice.